Guys, hello IP friends, welcome to hashtag IP series with your favorite podcast host Rita Anwiri Chinda. Now, if this is your first time joining us, I just want to say welcome to hashtag IP series, where we have conversations on copyright, trademark, patent, industrial design, trade secrets, plant variety, and geographical indication. And for my returning listeners, you guys know how we do it here, right? I mean, you guys have been consistent. Just want to say I appreciate you guys. So as we're rounding up, I just want to say thank you for all the plays and the retweets, the likes, all for everyone who has ever shared my podcast or listened to it. I just want to say thank you guys for everything. So yeah, if this is your first time, please don't forget to favorite or subscribe on any of the platform you're currently listening to hashtag IP series. And with that, I will be going straight into our conversation for today. So, for the last 3 years, I have been doing what I call the hashtag IP series Christmas edition highlights for each year. So I started in 2019, where I had about I had about 10 to 25 IP highlights for that year. I would have loved to run through them, but I wouldn't want this episode to be really long. So I started doing this every 25th December. I mean, I was just thinking what I was going to do for the year, how to let people into my own personal world, how I come about with my stories and the stories that actually stuck out for me. And I just sat down and I put down a couple of cases. So yeah, for the first edition, which was published on the 25th, I did that. I had about 16. So yeah, I just went through the post. I had 16 highlights for that year. So if you guys will permit me, I'll just run through them quickly, then down to the second edition and to the recent edition, which is the third edition. So 2019, we had the Please Call Me case. We had the Google Oracle case, which also featured in this third edition. Crazy, right? And I had the Dela Sage case, where she asked people. So she had registered her famous Kumole design. I don't know how many people follow Dela Sage, but she recently, that year, she had registered the design of her Kumole Candidas collection, and she put out an IP notice saying intellectual property notice violations will be prosecuted. And I found that really intriguing, because I know I did see a comment where someone was like, "Oh, you can't do this, you can't just." I just had to say something. Then another case that stood out for me was the Adidas losing his 3-stripe trademark battle at the EU court. And then we had the case of Sony Music, Universal Music Group, Warner Music Group, EMI, and 53 other companies against the cable and other internet service providers. So internet service providers and the famous blackface against Two-Face dispute over the song African Queen. So those were the cases that are sort of featured in my highlights. And then image rights, the whole paparazzis suing celebrities for reposting their images, that featured in 2019. So you can see that it's a recurring trend that keeps popping up every year. Then in 2020, I had the Lady A against Lady A. So Lady A used to be so Lady A was formerly known as Lady Antebellum. That's the band, a countryside band, changing their name from Lady Antebellum to Lady A, suing a blues singer called Lady A. Her real name is Anita White, but she had been using the name Lady A for over a decade, and they tried to buy her off. She didn't agree, XYZ, how the the whole story goes. Then we had another interesting update was having a new World Intellectual Property Organization Director General in the person of Darren Tang, who assumed his function as the DG on the 1st on the 1st of October 2020, and it will run for 6 years. So his tenure is going to expire in 2026. Oh yeah, we had also the Nicki Minaj and Tracy Chapman case, which I featured Mark Jaffe on my podcast. You guys should please check out that episode. Let me get the episode now. So it's so that was episode 16, where I had Mark Jaffe come share his thoughts on the Nicki Minaj Tracy Chapman case, where Nicki Minaj had reached out to Tracy Chapman saying, I want to sample Baby Can I Hold You in my song. And Tracy said she did not give her the authorization, but Nicki Minaj was like, okay, let me just go ahead and record it. I hope she changes her mind. And then she went on air to the DJ, one of the famous DJs in the United States, about it. He played it. Tracy found out about it, and then they went to court. But parties still ended up settling out of court. So, you guys can check out that episode to get more dates. Then we had, interestingly, we had another case that I would like to refer you guys to. In 2020, we had the Gareth Bale and Zlatan Ibrahimovic, who sued EA Sports over the use of their names and images in video games. That's another huge area that I've seen a lot of disputes emanating from there. I think 2 days ago or yesterday, I did see a post where it was stated that Jet Li had been approached for them to get his move for the recent Matrix movie, and he refused, saying that he had seen what the future was going to be like for celebrities and people like him, and he did not want a situation where his moves would be reproduced in future. So I'm trying to read out the post so I don't misquote him. So his reason for turning down the big role in the Matrix Reloaded and the Matrix Revolution was, for him, he said it was a commercial struggle. He realized that Americans wanted to film him for 3 months, but for him to be with the crew for 9 months, and they wanted to record and copy all of his moves into a digital library. We know now we're in the digital age, so it's easy for anyone to just reproduce your work. And then he said at the end of the recording, the rights of the moves would go to them. That did not sit well with him. So he said he was worried that the future technology will allow the United States filmmakers to digitally reproduce his moving body and superimpose the face on any actor into it. So he was thinking, I've been training my entire life, and real martial arts could only grow older, yet they could own my moves as an intellectual property forever. So I said I couldn't do that. I mean, that's the one that's thinking far when it comes to apology. When it came, oh my god, I'm so messed up right now. Okay, scratch that, please. Scratch that. Oh my god. Okay, moving on. Okay, so we're moving on to another case. So we had the Michael Jordan against the Quadam Sports Co. Limited, who in the 90s and the 20s filed a trademark application in China, which included the trademark for a jumping basketball player silhouette logo that bore more than a passing resemblance to the famed Jumpman logo. Then we had another case. So I'm just trying to skip through all of the cases, and we had the famous TikTok signing exclusive licensing agreements. The pandemic and the lockdown brought up a lot of copyrighted issues. So from the DJs having their songs being taken down for copyright infringement, to artists complaining that people were using their songs without license and creating content on the most famous social media platform right now, TikTok. Then Pitbull sound mark registration for that was crazy, guys, and that blew my mind. And reading the article about that, I know they said it took them about 18 months to actually get the registration for that. So you know there's sometimes when you hear the Grigo yell and you're like, oh, so he's being featured, but then you don't hear his voice. That's like a sample. So that's the way for artists to commercialize their creative work. I did a post on that dated 21st April 2020, so you guys can check that out. Then we had the issue of the Nigerian government issuing a new regulation prohibiting exclusivity of sporting rights in Nigeria, stating that for instance now, DSTV has the Super Sports license, sports broadcasting license to stream football matches, Premier Leagues, and then the Nigerian government is saying, oh, you have to sub-license that right to people like NTA and the rest of them. And that's, people were really having it. And then we now had the NBC code, the 6th edition, so it felt like there was a lot of clampdown on the creative space. And we know that sports broadcasting rights are freaking expensive. And then we had the famous Cynthia Morgan case, not understanding contracts. We had the Kanye West rants. I think that was like the highest tweet ever. Then I did a side recording on intellectual property rights that exists in video games and the synchronization rights or licensing. So, because we had two Nigerian artists that were featured in the FIFA 21, their soundtracks were actually featured. Their songs were featured as part of the soundtrack for the FIFA 21. So we had Fireboy, DML, and I think Rema. Yeah, I think Rema. So I did something on that. You can listen to the podcast version. That's episode 14. So we're heading straight down into 2020. I know we're going down memory lane to tell you how far I have come. And I'm really grateful for everyone who has ever taken their time to retweet. I always look at my impression and I'm amazed at what you guys are doing. So let's get into 2021 IP series Christmas edition highlight for 2021. I think I'm repeating 2021 again, but I guess I'm just excited because it means that we're building up into our 5th anniversary. So this is something that I want to be a long-term goal. So maybe with time we'll have the live sessions where I have people come on, we just have that interaction. But that's something I have to sit down and really think it through. Okay, now drum rolls as we start the 2021 IP highlights. Okay, now let's get into it. So I had about 20 cases this year, and I was even amazed. I think there were a lot of interesting cases that really stood out for me this year, and I did not know how to cut the list. I even had to scrap out a few when I was writing because I saw it was almost getting like 25. I was like, no. So number one on my list for this year is the non-fungible token. That's the NFTs. NFTs have been like the buzzing word for 2021, which I consider to be like post-COVID incentive for creative. So I did see an article or a post yesterday or day before yesterday where someone was saying NFTs for hustlers, and I kind of just thought about it because now we're having NFTs disputes where people can actually mint images of you without your consent. I know Beckham's is or Herms, either Beckham's or Herms are actually fighting someone about that because the person basically minted a virtual luxury brand, and they were not having any of it. They even went as far as sending him a season. So it's Herms. So Meta Birkin's creator says he received a cease and desist from Hermes, and he's relying on the fair use principle. Now, the fair use principle is an American principle, whereas for Nigeria we apply the fair dealing principle. I think I'm switching it. No. Fair use, fair dealing. Yes, fair dealing is for the US, fair use is for Nigeria. Yeah. And those are one of the issues. Then I did see another post on Twitter where this lady said someone had minted her picture that another photographer had taken of her, and she was not impressed. She did not like it, and the conversations just kept growing and brewing from there. and I just thought to myself, it is supposed to be like an easy way out for people, but then I guess people are not taking advantage of the virtual reality platforms and stuffs like that, and the conversations are just going to keep coming and coming. So I had stated that if you intend to commercialize or resell or exploit someone else's NFTs, or in this instance you want to mint someone else's picture or image about them, you have to get consent, permission, authorization. I know that's very important when we're talking about intellectual property. Get a license. It could be an exclusive license, it could be a non-exclusive arrangement. And also, what people need to know about NFTs is that it is an intangible asset. That means it can be sold. It can be assigned, it can be licensed, but in this case, the buyer only has the propriety right. That means you only own the property of what you bought. You don't own the rights that was expressed in that property that you actually bought at the end of the day. So that does not make you the owner, because there was no rights transferred. And we know IP gives exclusive rights to the owners of the works. Major IPs that you would find to be common in the NFT space would be copyright, design right, trademark, patent, and maybe, just maybe, trade secret. So that's it for my first highlight for 2021. So highlight number 2 is the biggest stadium naming rights deal that took place last month, which saw Crypto.com buying the naming rights to the Los Angeles Lakers Staples Center in a 20-year deal for $700 million, which took effect on the 25th of December. So 20 years from today, that's when the deal or the partnership is going to expire. Now, stadium naming rights is a very, 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 very lucrative business models, which involves an exclusive type of sponsorship and advertising in the sports industry. It's a way for those within the sports industry to commercialize and exploit. So there's a lot of funding that's needed in the sporting sector. You need to raise funds for taking care of the stadiums, merchandising, adverts, sponsorship, you name it. You can use it for event centers, as an event center. It increases also the value, which helps increase the value of the intangible asset, and also you take a good look at the financial agreement. For instance, I did see a post recently which said there was a 30-second ad worth $6.5 million that would be published or broadcasted on the 13th of February at an event that will be taking place. Another benefit is the community's image. So if the image, let's say, is in somewhere, say Surulere now in Nigeria, the image of the community would help in some way when it comes to credibility, tourism, branding, you name it, and also acceptance. So it brings a lot of people there, and the locals will also have to put their best foot in front at the end of the day. And yeah, that's it for that. Then things to look out for: the range of the rights, whether it's image rights, use of the name, the logo, the venue, payments mechanism, types of sports. So you guys can also check out my friend's book, A to Z of Sports Law and Business, a practical introductory guide, sports law and business in Nigeria. So it's published by Olisagbakuba Legal. Check it out. It's a very small book, but fully loaded for those that want to branch into the sports sector. I want you to notice that naming rights are not only exclusive to the sports industry. Event centers for entertainment or esports sectors can also explore naming rights at the end of the day. Now, remember when I said the copyright infringement cases between paparazzi and celebrities keeps growing and building? So and I've noticed that in the 3 highlights for that I've had so far, I've featured 1 or 2 cases. And this year I have another case between Blake Lively. I so much love her. She's currently being sued by a photographer named Robert O'Neill for posting a picture of herself from 2018. Can you imagine? 2018. And then she posted it this year, so 3 years later, sometime in August, on Instagram, and he's saying she did not even license it or even get my permission before posting. Another celebrity that is being sued is Lisa Rinna, who is being sued for $1.2 million for posting images of herself, unauthorized pictures of herself and her daughters. I mean, that's crazy. She's being sued by one of the biggest photographing company, that is the Black Grief USA Inc. So I get the point where photographers can retain copyright in their expression in a tangible form, but what happens to the person's privacy? Did you get my consent first? So I think I talked about that in my review as well. We have a Nigerian case where an employee whose picture was taken, and later her company went into an arrangement with another company and had her face on billboards in 3 different areas in Nigeria, cities in Nigeria, and she wasn't having any of it because people thought she was being paid for having her image out there. So all of those things. But then again, I get the copyright aspect where you need my consent to be able to use my copyrighted work. So what I'm going to recommend that I do is that, first of all, if you don't want someone to take a photo of you, please tell them to sit down. This is so if you travel by road in Nigeria, you have instances where you make stops and you have photographers want to take picture of you. I always tell them, please don't take pictures of me, because I don't know how I'm going to react. I probably just freak out when someone takes a picture of me without actually telling me. Then if that person refuses to stop, then you can sue. But then it's really tricky for celebrities, because people always say, you put yourself in the public, so you deserve everything now. And I like to always refer to this Naomi Campbell case because it gives me so much joy. And also the Rihanna case with Topshop. Those are like my 2 go-to cases when I'm talking about photography case, right to privacy, data protection, and all of those things. I always refer to those cases. But then the US jurisdiction has its own format. So if your photography or your photograph is not registered, you can't go and be suing someone. So I'm sure most of this and that's all thanks to Gigi Hadid, whose photography case was so viral last year, and also Emily, I don't want to spoil or mispronounce her name, so let me take my time to actually pronounce this name. So it's Emily Ratajkowski. Yeah, she has a very big copyright case on photography. You guys can follow that story. It's really, really interesting. I mean, you find out from this case that celebrities also have, they need privacy at the end of the day. So you take a picture of me and I like it and decide to post it, and then you try to use the law to fight. There's really no balance. But then let's keep it that way and keep moving. You get and Now. If the picture was taken with your consent, please sign a release form or a work for hire agreement, because copyright grants authorship to the first person who expressed the photo in a fixed or a tangible medium, thereby giving them control and exclusive rights over the photo. So, please, can I take a picture of you, or would you mind taking a picture? Can I take a picture of you? Would you like me to publish it? Or you just tell the person, so I'm going to take a picture of you, I'm going to put in XYZ, negotiate and the rest of it. You get. Then case number 4 is the famous Olutori case against Ebony Life Media, who was accused of copyright infringement of the Olutori. So in that case, brief summary, Olutori basically so basically Ebony Life was accused of copyright infringement in the story, where Tobore claims that they had reproduced her life story without her consent, and there's a whole big drama about that. So I had to watch the movie to be able to come up with my own opinion about that case, because I had a few requests from people who wanted me to actually share my thoughts and views. So you can check out the Twitter version, which is dated 2nd of February 2021. And then you can also check the podcast version, which is episode. If you guys hear my mom's voice in the background, please bear with me. Which is episode, let's see. Oh my god. So let me get that and get back to you guys. The Olutori case is episode 30. Episode 30, and I shared my views. So I did put up a poll, and I also made reference to the Kiki Modu case with regards to giving credit, acknowledgement, what intellectual property theft really meant. I know a lot of people were for Olutori. A lot of people were supporting Tobore. I think a lot of people were supporting based on sentiment. But then, what I discovered in the course of my research was how I just basically separated each of the issues, from IP ownership to IP theft, to intellectual property rights that exist, to the what's life stories and IP work made while you're employed, inspiration against copying, and I also had to explain authorship and ownership when it comes to copyright. So you guys should please check out that particular episode. Most of the polls I put up had a lot of high votes. For instance, I had one that said, does the fact that Tobore was employed at Premium Time mean that she had transferred her intellectual property rights that was exclusive to her as an author? And remember I said the Copyright Act, that's the Nigerian Copyright Act. When I'm referring to the Nigerian Copyright Law. The Nigerian Copyright Act Section 10 provides that when Section 10(1) says the person who expresses the work authorship shall vest in the first person who creates the work. Shall means compulsory. Then the exceptions are while you're employed, if there's a contract, or if it's a work for hire, it belongs to the person that employed you or hired you. So please check out episode 30. Thank you. Then another interesting case that had to make it to my top IP highlights that I found really interesting and was controversial as well was the case of Omotola, Dr. Omotola trademarking her name Omotola. So she made a post, Omotola is now trademark, and people were like, no, you cannot do that. Omotola is a Yoruba name. You can't own Yoruba names. You can't own it. That means you're restraining others from bearing the name Yoruba. And I was like, please, you guys, take a deep breath. Breathe in, breathe out, breathe in, out. And I had to do another post again. That was dated 19 February 2021. I had to start from explaining what trademark was, what could be trademark, types of trademark, And I asked, so do you think Omotola as a mark meets the requirement of being deceased? And 77% said no. That That poll had 111 votes. I mean, guys, that's how controversial it is. And then I asked people, so which of these do you think is more popular, or more sexy, or more taller? And 118 votes came in. 78 said almost sexy, that she should have stuck with almost sexy. While 22 people said Omotola was popular. I mean, Omotola is her first name, you get. And as a celebrity, you are entitled. Your name, your image, and likeness can generate money for you. If you don't do it, another person is going to do it, and there's nothing you can do. However, your reputation and goodwill might come in, so you have to be very strategic and smart about it. Benefits. I talked about the benefit of registering a trademark as well. So I also basically I also have a podcast version of it. I try to do a podcast, a Twitter version, and also a blog version of all of my conversations. For those that so currently Twitter have been banned in Nigeria, so if you can't read my tweets, you can listen to the podcast. If you can't listen to the podcast, you can read the blog. But then there's a beauty in having access to all of it, because one, the informations are always different and relate differently, you get. So yeah, so episode 32 is where you can find the culture of celebrity branding, expectation of their name and likeness in regards to the Omotola case. And trust me, you guys are actually going to enjoy listening and reading about it. Then number 6 is trademarking of the words Yoruba. That's another interesting and controversial case this year. I mean, the internet was buzzing for a week. God. So if you're interested in the Twitter version, it was posted 30th August in celebration of the World Photography Day, which is every 19th of August. Then number 10 is my short review of the Nigerian Plant Variety Act 2021. I also published a podcast version. I'm yet to work on my blog version. Don't know why. I guess I'm just being really lazy. But the Twitter version was published on 21st of December, and the podcast version was published 28th of December. Yeah. So it's still pretty recent. You guys should check it out. Let me know. I feel this is like a step in the right direction, because one, Nigeria is so blessed with a lot of resources. We have enough plants, fruits, seeds, everything. My mom is Benue, so trust me, guys, as the food basket of the nation, I can assure you guys that we have loads of things agricultural wise that we can export instead of keep importing every freaking time. We need to do a lot of sensitization. The Ministry of Agriculture needs to do a lot of work. There has to be a lot of collaboration. All hands needs to be on deck for this to work out, because once we begin to take all of this seriously, we're not going to be complaining about poverty. Although the government has a lot to do in terms of security, funding, access to material, education, collaboration, research and development. We have a lot to do. We need a fertile ground in terms of, there's a lot of tribalism going on. There's a lot of religious fight. There's a lot of politicking currently affecting our system, that we're not focusing on building Nigeria. I mean, we're supposed to be like, we're no longer the giant of Africa, which is embarrassing. But I mean, we're still doing good. But then, statistics keep saying we are going to be amongst the top fastest growing countries in Africa by 2026. I know a lot of people are also giving up hope at the end of the day, because of what is happening. But yeah, I feel this act was in the right direction. The only issue I have with it is the fact that no one really knew that this was going to be assented to. There was no public hearing. It was like a hush thing and rush thing. I feel the document should have been more. They should have done it better. You know what? Never mind. Let's just keep going on. Right. So, I mean, two British and owner of an outwear retail company called Timbuktu trademarked the word Yoruba and had opposed registration of culture trees registering Yoruba stars. I mean, culture tree only brought it to the attention of the internet because someone has stopped her from registering Yoruba stars. I mean, there's actually Yoruba in your mark, in the proposed mark to start with. So if someone had not stopped you, they've gone ahead to register it without blinking an eye or thinking about the Yoruba or cultural appropriation. So that was a very dicey conversation. I would like to appreciate everyone who tags me on trendy IP cases or trends, people that reach out to me privately. I appreciate you guys. I got tagged on that post a lot, and it took me a while to put out my view because it felt like everyone wanted to talk about the case, and I'm not someone that likes to follow the crowd. I like to do things at my own pace and time. So yeah, Yoruba is not for sale. So there are several conversations about indigenous work, cultural appropriation, if there are international frameworks that prevent misappropriation or misuse of cultural works. So I have so let me start with the Twitter version. Twitter version was published on the 7th of June. Yeah. While the podcast version was published on the 30th of June. So that would be episode I keep forgetting, guys. Let's see. That'll be episode 44. Whew, I've done a lot. Not to brag, but yeah, episode 44. So listen to it, and I also have a blog version of it. I think that was about the same time I started my blogging. So that was like, I think, my first blog post or second blog post. Now I can't really remember unless I check it. But I've been I think these cases so far have been the ones that stood out for me this year. And so we are moving on to the next case. We had the 10-year battle between Google and Oracle, where Oracle sued Google for copyright and patent infringement of copying their 11,330 lines of computer code, as well as the way it was organized to create Android. So this was an interesting case. I had to bring in an expert to talk to my listeners about it. I only have a podcast version about that. I had to reach out to, so I was referred to Rick Sanders on Twitter by I reached out to Mark Jaffe. Mark Jaffe referred me to another lady. I'm trying to remember her name. And then she referred me to Rick. And she's like, Rick has been following this case from the onset. Just reach out to him. And he was gracious enough to, have this conversation with me. Despite the time difference, we just had to fix a time that was comfortable for us. And then I made a bit of he did make a bit of a reference to the Warhol case. But I did talk about the Warhol case in another case while I was doing one of my reviews. And we talked about how this case had impacted the software industry, what are the trends to look out for, why the patent claim was dismissed. I mean, a lot of people are focusing on the copyright aspect, but no one realized, or most people did not know, or most people are not even paying attention to the fact that there was a patent infringement claim as well. Then we had to talk about the fair use principle and the 4 guiding factors that the Supreme Court had used to come up to their final decision. So you guys can check that out. That was published on the same day as the World Intellectual Property Organization Day. The World Intellectual Property, World IP Day, World Intellectual Property Day, which falls every April 26th. Yes. For ease of reference, let's do this again. For ease of reference, now number 9 is the case on image rights issue between Oluwadamilola Banire against NTA Star TV Network Limited, which was dismissed at the Court of Appeal in Nigeria, stating that the claim for image rights and thoughts of passing off did not apply because the ownership of the copyright in the photograph belonged to Banire's employer, who was Virtual Media Network Limited, who had gone into a channel licensing agreement with NTS. I felt that case was not fair. I felt the court did not do justice to that, because that was a good opportunity for the court to set precedent on that case, but the court did not do so, and I wonder why. I mean, I would say I was hurt, but I guess I expected so much from that case, because I got tagged on that case when it was published by my mentor, Max. Max was one that tagged me on, Maxi Combeck. You guys should please check him. He's also a very good IP lawyer and IT lawyer, and also a good arbitrator, and a current ICC representative from Africa. So check Maxi Combe out. So I did a podcast version which I tagged intellectual property rights that exist and the rights of a photographer. That's episode 48. You guys can check that out. Then the Twitter version was okay, so I didn't do a Twitter version in this case. What I did was a blog version. So just check IP series on Substack, guys. That's where you would find the story about this case. So like I said, for ease of reference, it's episode 36 in my podcast. So you can listen to my podcast on Anchor, Spotify, Apple, Google, Breaker, Radio Public. Yeah, so just put hashtag IP series. The hashtag has to be included. That way it's easy for you to, find my post. Then we had lots of fast fashion dispute this year, featuring Shane, Boohoo, the Kai Collection, Hanifa, Pretty Little Things, and Fisaye Longe. The fashion industry is like a very interesting industry. It features the same thing, has like a multi-layered protection in form of name, logo, symbols, combination of line, visual appearance of the dresses, accessories, everything. And for someone in the fashion industry, intellectual property plays a very important role. Fast fashion is said to be a business model based on stealing high fashion. I feel it's not just high fashion, because you see high fashion brands stealing low fashion. Let me not call it low, but stealing smaller fashion brands, designs, and mass manufacturing them and selling them for either lower quality or higher quality, with unimaginable cost to people and the planet. So this is for those that focuses on sustainable development in relation to the fashion space. You're talking about recycling and the rest of it. So the sector takes advantage of the loophole in providing affordable clothing, and big brands are not left out in the copying industries. I mean, no one should be surprised. You get, fast fashion isn't free. Someone is definitely paying. And thanks to social media and the internet, the reproduction of creative work is now easy because of access. List of serial fast fashion brands who have been accused of copying. Definitely you have Pretty Little Things. You also have Givenchy, who is not also a scent. He was accused, or they were accused of allegedly copying a black designer's zipper motif hat. We also have the case of Kai Collection and Boohoo. Then there's Kim Kardashian and Misguided. There is also Old Navy by Gap against Carrie Ann Roberts over the use of the phrase on a t-shirt, raising the future. So you see that slogans can also be trademarked on fashion statements. So Off-White also relied on that as well. I'm going to be talking about Off-White later. Then Zara. I love Zara. I really love Zara. Then you have Nasty Girl. That's another brand. I like that. So Balmain, Missy Empire, and Nasty Girl. I mean, come on. ASOS. ASOS is not also left out from the whole copying of style. Forever 21 seems like they're serial copyright fast fashion stealers. Then we had the iconic Versace jungle print Barocco print dress that was copied by Fashion Nova. Fashion Nova is another serial copier in the fashion industry. So that's a very interesting episode. I did a tweet about it on the 20th of April. I also went further to publish the Twitter version, which is episode 37. So I published that May 16th, a day before my birthday. My birthday is May 17th, guys. Please take notes. But yeah, so I tagged it fast fashion, the world of serial copiers, interplay with intellectual property. So let me know what you guys think about it and if it was worthy of being on my list. Okay, so another highlight for me was Facebook changing its name from Facebook to Meta. And their purpose for doing that was basically to broaden their reach beyond social media like virtual reality, with the hope of becoming a metaverse company sometime in the future, because metaverse is another word that is buzzing, and you're seeing a lot of luxury brand especially wanting to have their own collection. So the process for changing a name or a mark as a name in Nigeria is you have to apply to the registrar that you want to cancel or change your name or correct something in line with Rule 86 of the Trademark Regulation, which provides that you must apply to the Trademark Registrar in line with Section 40 Sub 1, by either through the registered proprietor or by such persons by filing Form 22, and you'll be also required to provide the statutory declaration. Apologies. So Rule 87 also that talks about what I just read. That's providing the statutory declaration. So to the buzzing word as to why I had to put this in my head, that was because it sort of felt like it was a David and Goliath battle, where a company called Meta Company accused Facebook of selling their name Meta after they had refused to sell the name to Facebook because the offer that was given to them was very small. Now my first question was, or to my listeners, is do you think the name and logo are similar in nature? Do you think there's going to be a likelihood of confusion when you see Meta for Facebook and the Meta Company, who is a tech company, while Facebook is like a social media connecting networking platform? To answer this question, I would crave your indulgence to listen to the podcast version where I talked about the case of Chanel and Huawei over likelihood of confusion in the interlocked C. So Chanel is like interlocked double C. So Huawei has a similar, Huawei has a logo that looks like it's interlocked, but it's not interlocked. And I did a Twitter version on the 30th of April, where I did a podcast version on that. So I published the podcast on the 18th of June. You guys can check it out. So that will basically answer your question. We are trying to compare if Meta Company and Facebook Meta are the same at the end of the day. I also talked about opposition, so that it's basically just, check it out. Then my next case another case that I also referred to was the yellow Danfo bag case between Vera Amber and Olorun Shola Emmanuel over the design a yellow Danfo bus bag, which she herself, that's Vera, had designed in a competition that she participated in. So I did a Twitter version of that on the 10th of January, which I started by saying, so my intro was more like Ariana Grande's song 7 Rings. You want it, I want it, I got it. I want it, I got it. Because Emmanuel had basically reached a similar case. Emmanuel had reached out to Vera, made an offer, she refused, and he still went ahead to reproduce her bag, cheaper quality. It was awful. really awful. So yeah, and he felt like he was in the red because according to him, I already reached out to you and I asked for consent. It's not like my offer, so I went ahead to do, well, But in this case, I think it's a lot different. But I hope you guys see where I'm going with this. So that is case number 11. I mean, we're almost wrapping up, thankfully. I have 9 more cases to go. But surprise, it turns out that Mark Zuckerberg's wife had a company with the name Meta since 2015, whereas Meta company started using their name in 2016. So he just had a lot of controversies about this. When I read, I was like, are you sure these people did not see the future and like, okay, let's go and register it and wait for them to come, But then you never know. We'll see how that pans out, because I feel like the case has died down, but I don't think there is any confusion. I just think they're trying to take advantage of the new buzzing word meta. And besides, that's starting to seem like it's going to be like a generic term or word at the end of the day. I hope not. But yeah, let's move to case number 12. So for case number 12, it's a rather sad one, but I did not want to focus on the sad aspect of the story. So the director at Louis Vuitton and the owner of Off-White, Virgil Abloh, died this year. He I think I'm having difficulty talking about this because no one likes to talk about that, but I guess I basically just want to focus on the IP elements of this story, which is how he explored and commercialized his intangible assets. So he did a lot of collaboration with notable brands and luxury brands like Nike, Rimowa, Jimmy Choo. His brand Off-White had an unregistered mark, which was a white signature diagonal stripe motif which contained 15 or 19 stripes. We also had quotation marks around a sans serif capital letters, arrow and black and white diagonal line. So I would want people to focus on the IP elements and not the debt. He did leave a good mark, and I know a lot of people were so into Off-White as a brand. So may his soul rest in peace. And yeah, okay, let's move on. Okay, so case 13 is the Davos artificial intelligence debate, which caused a lot of controversy again, because so I don't want to put this as a white against black case, because so we had an instance where Omicron was the arrival of Omicron in the continent or in the world was an African country that notified the world that there's a new variant out there, whereas the developed, or I don't want to say so-called, but then we had the other countries who were already aware of it but kept mum because of whatever agenda they had. And when South Africa blew the whistle, they just reverse engineered the whole thing and started crying wolf, Africa this, and then they were quick to put 13 African countries on the red list. Seriously, guys. So this was the same case when the South African when a patent for the Davos artificial intelligence was issued. The patent was issued, and the UK, the US, the EU IPO, they were all against it, saying a non-human cannot be an inventor. Only Australia said yes, a non-inventor can be an inventor. A non-human can be an inventor. So that is still an ongoing debate. I didn't want to say much because I'm working on the newsletter version, which I feel will be I promise I'm going to publish it this week, but I do not think I'll be able to meet up, so I will be postponing whatever pending newsletters I have to next year. Bear with me, guys. It's not easy. I'm really trying my best. But yeah, the Dabbles AI case, the Dabbles artificial intelligence case made it to number 13. So number 14 is like a project I'm not excited to see it go, but then I guess they've checked everything and they've decided, okay, I think this is the best route to take. So the World Intellectual Property Organization WIPO in their publication stated that they would be discontinuing the WIPO proof project that was created as a trusted digital evidence for intellectual property asset effective from 1st of February 2022. When I saw that, I was like, oh gosh, what happened? Because it seemed like a very good project and being championed by one of the best intellectual property organizations in the world. But I guess they have their reasons. So we're moving on to number 15, which is the Nigerian Copyright Bill public hearing, which was held sometime in October, I think. I mean, that brings hope to creatives, intellectual property practitioners like me. Because I know while I was doing my PhD in apologies. I've not yet done my PhD, guys. Okay, I think I'm speaking into the manifesting right now. So yeah, while I was doing my master's at the University of Derby, I think that was towards the end of my stay. We did see a publication asking people to send in comments about a copyright bill. I mean, there was so much excitement. That was in 2015, guys. 2014, 2015, and now we're in 2022, and we are doing another review, public hearing, hoping for the best. So they had like a technical meeting in October. Then they also had a public hearing in Abuja. I couldn't attend that because I stay in Port Harcourt. And I guess the notice was a bit short for me as well, so I really couldn't participate. But now, fingers crossed, we're hoping that the Buhari government signs that into the law, because there are a lot of new innovations that I feel will cure some IP related disputes in the digital age. So we're looking forward to that bill being passed. At least it can tackle some of the issues we're having currently in Nigeria. So my 16th IP highlight for 2021 is the Fizz drink sound mark that failed to be registered. So in July 2021, the European Court of Luxembourg ruled that the Fizz sound of a drink followed by several seconds of fizzing can't be trademarked. An adult metal beverage holding had applied to the EU IPO, that's the European Intellectual Property Office, to register the noise made by its fizzing drink, but it was rejected. So they had to appeal that rejection. So now you know that applying to trademark, you can trademark a name, a sign, logo, symbol, sound, color, smell, but you have to meet the basic requirement of it being distinctive enough. So under a Nigerian trademark act, there's a provision that you can write to the registrar to seek their view as to whether or not your mark meets the basic requirement. I don't know how many clients will be patient or not, because registering the trademark alone is a hassle. And I always tell my clients, if you're going to do that, please exercise patience with me. It's a long waiting game, so I appreciate if you guys would just be patient with me. Now, another beautiful thing and function of trademark is that it's considered to be a source origin, making it easy for the customers or consumers to be able to recognize it without even getting confused. So they are applied to the European General Court, who agree with the decision of the EU IPO, stating that a sound mark must have certain resonance which enables the target consumers to perceive it as a trademark and not as a function or all element or as an indicator without inherent characteristics. Now take note that registering a sound mark, like every other mark, is not an easy feat, because there are certain Assessment focuses more on the distinctiveness test. Sounds are considered to be non-traditional marks that can be a trademark. It can be registered and protected in the territory the owner wants to, but you must meet that test. It is very important that you pass that first test. Where you fail, just got to let it go. Let it go. Let it go. Okay. Number 17. So. Number 17 is the Black TikTok strike. So this happened within the Juneteenth period, where content creators and TikTok influencers who were of Black origin refused to put out that content, calling out the social media platform from actually acknowledging them, and also their other colleagues who were white, for cultural appropriation of their work on the app. So you find that a viral TikTok dance will go out there. So for instance, the Savage remix, Cardi B's up and it's up and it's up and it and then a white girl will come and do her own verse, and then she goes viral. We're even getting invited to shows like Jimmy Fallon show to come and perform, Ellen DeGeneres, and all those things, and we're getting paid. Meanwhile, the blacks, the TikTok influencers who are of Black origin were not being appreciated. So they're like, nah, we ain't having any of this anymore. And they, we went on break. Actually went on break. So I did a blog post about it. I think that was like that's like my third post. So you guys can just check it. Like I said, I hashtag IP series on Substack and read my view on IP protection for dance. I even, attended a series of webinars who talked about dance protection, of protection of dances as an intellectual property. So there's a word for it. I'm trying to remember. Just give me 2 seconds, guys. Breathe in, breathe out, breathe in, breathe out, breathe in, breathe out. Okay, when I remember, I'll just mention it, but yeah. Okay, so there was a recent update after I made that publication with regards to Black content creators and dancers and their intellectual property, with the help of Logitech and award-winning choreographer Jacqueline Knight, who got copyright for 5 other creators who were Young Deji, who is the creator of the World Dance, Fallout Quartzland, creator of the Doja's Cats, Say So, Why Don't You Say So, Didn't Have to Know that. Okay, we're not karaoke right now, but yeah, it was performed at the 2020 Billboard Music Award. Then the Nene Twins, creator of the dance to Megan Thee Stallion Savage remix, yada 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 yada, featuring Beyonce. Then we had Chloe Arnold for Salute, a legend choreographed for Syncopated Ladies, and then Maya Johnson and Chris Cotter, creators of the Up Dance to Cardi B's single, and it's up and it's up and it's up and it's down. First of all, the Savage Challenge TikToker Kyria Wilson earns her copyright thanks to Jacqueline Knight and Logitech. So yeah, people are beginning to see the effect of social media platforms where copyrighted was originality is being taken for granted, misappropriation, all those conversations start to build up, and we know how people get tense when these conversations are ongoing. Then we have number 18. Call me what you want, call me what you need, call me when the money I'll be on. Now, the famous Satan shooter got a lot of controversies. We had churches making sermons and the rest of it. So this is the case between Nike and Mischief. Now, Mischief is known for doing mischievous things. Let's just put it that way. So in March 2021, Nike sued Mischief for unauthorized use of their logo on the 666 pairs of the Satan shoes made in collaboration with Lil Nas over the release of his song Montera, Call Me By Your Name. So when that case happened, I think I always freak out when things like this are being debated. So I know when the whole Illuminati conversation started, I loved this Chris Brown song, what's it called, Falling Angel. I stopped singing. I deleted it from my phone. Disturbia, the same thing. And I was like, nah, I listen to Disturbia and I'm not freaked. Same thing with Falling. I mean, I love them both. I mean, when this song came out, I would not even dance or bob to it. I wouldn't bob my head to it. But now I'm over it. I'm like, F it, you know. So, that was a very controversial case. However, the interesting thing is, alternative this resolution came to save the day. Parties went to court, but they ended up settling out of court, which is like the beauty of arbitrations. Parties are still friends. Nobody's like, oh, you're my enemy, don't cross this boundary, blah blah blah, you know. But they did come to an agreement that they were going to actually refund money to those who volunteered to return the sneakers in a voluntary recall. And you know, Montera has gone ahead to, you know, be a viral sensation. I mean, that was like a good stunt from Lil Nas. So yeah, I think we're almost rounding up now. No, I think we are rounding up. We're going to number 19. Woo! So our number 19 case today is the CBN against the eNaira Limited case, where CBN decided they're going to launch their own eNaira, their own digital currency, and then this company named eNaira Limited. And first of all, guys, why would you even call your company eNaira? You do not have respect for your country. Like, seriously, fam, why would you even do that? So I think I'm ranting. Let me take a deep breath. Okay, I'm done. So basically, first of all, whoever helped you register that was in the wrong. And secondly, challenging a government agency for, you know, trying to be proactive I don't think it was the smartest move ever. You get, you know. But I guess it's one of these things that happen. But yeah, that was another very controversial one. People were like, oh, why would CBN do this or that one? It's another way for the Nigerian government to siphon money from its people. You know, the conversation just kept going and going and going. I did not really want to weigh into it because I felt like I did not really understand the case so much. So I had to take my time. I like to take my time. I don't like to rush. Especially when I know that I have people who are counting on my people who are counting on my opinion as an individual, so I would not want to mislead anyone. So I even had my mentees also ask me questions about that, and I had to, you know, refer them to a comment by a colleague. So we applied the first to file principle in Nigeria, that is correct. But then Naira is on the exclusive list in our constitution. E is a generic word. Naira is, you know, it's too descriptive because Naira is our currency. Why would you even do that? You get? And on the other hand, the company itself does not even have a full registration of the mark. The IP lawyer should have advised him. I mean, not even the IP. I mean, from the moment you said you're going to register eNaira as a company, your lawyer should have told you, nah, man. Then you now went further to say, oh, you're going to do a trademark. You don't even have a trademark registration. So your acknowledgement or acceptance does not qualify as a proper registration approval. You're still in the process of registering. So which is why I don't like to debate when it comes to costs. So if I bill you for registration, I'm billing you for everything. If you feel, oh, you got a cheaper offer, know that you're not getting your certificate at the end of the day, and that is going to be a sad one for you. Anybody can oppose the registration of a mark. Like I stated that before. The proprietor or certain persons can apply for that. So yeah, that's on that. For the on the eNaira, I feel this is like a classic case of an IP trust, one that went ahead to sit and wait to take advantage of it, and feeling that, oh, it's like what cyber squatters do. They register your domain name and they wait for you to want to register. Like we had the Nigerian Airways issue some years ago, and trying to take advantage of an IP owner who, for one reason or the other, failed to register their trademark or are reluctant or whatever. So we had a case that happened, and that this happened in India anyway, between Sony and a guy called Hitesh Aswani over PS5. So a man from Delhi, India, in October 2019 applied to trademark the word PS5, thereby prevented Sony from releasing PS5 in India in 2020 because of the territorial nature of intellectual property. However, parties opted to settle out of court, and Hitesh discontinued his registration. So if you follow the Twitter version of this IP highlight, I posted a picture of the discontinuation of the registration of the word PS5, but that was a huge stumbling block to Sony, because when they wanted to launch in India, and they found out that they couldn't do that because someone had put in an application to register PS5. So that was like, it put a hold on their release, but that was thankfully settled. Trust me, guys, the number 20 today. Anyway, okay, let's just head into number 20. But I hope so far you guys have enjoyed my highlights. If you haven't, I'm so sorry. If you have, please tell me your favorite highlight for 2021 in the comment section, while we go and chill for the last one. You want to chill with the big boys? So this is this song. If you're in Nigeria, you will definitely know this hype man song by Goya Meno, a Nigerian hype man called Goya Meno, and Ghanaian record producer Neptunes. It's like the Dirty December song. It's like last year when we had party after party. Now this year is you wanna chill with the big boys. Are you the wrong? Okay. I'll just stop here so that my content is not taken down from Spotify, because that would hurt my feelings, guys. But yeah, so few days ago, a day to Christmas, we just saw a post that Spotify had taken down Ameno Amapiano remix by hype man Goya Meno and Ghanaian record producer Neptunes, saying they had sampled Ameno. I'll stop there. It's a song owned by French new age musical project Era, and people were like, Dirty December, it's not gonna be dirty again. You get, but I think a lot of people were losing focus on the fact that someone had used another person's creative content without a license, without authorization, without permission. Those are like the basics, man. That's like the basics. You can't do without that, fam. So the interesting thing about this case is the fact that it's kind of has different elements to it, from fair use to getting licensing, to understanding authorship and authorization and ownership, So first of all, if as an artist, I know I did mention that in my last year's highlight I talked about sync license. So maybe when you started using Ameno, you did not know that it was going to be a viral sensation. But from the moment he started to get to that point, I think the best strategy would have been to reach out and say, I did this for private use. I didn't know it was going to turn out this way, and then it became a viral sensation. This is what I would like for us to, do. I'd like to get a proper license and authorization from written and signed by parties. So you have issues as to sampling and remixes, mashups, and the rest of it. Sampling involves you taking part of an existing sound recording and incorporating it into a new one. For instance, sound recording could be re-recording a piano line, a guitar riff, what else? Yeah. So when you sample those things, when you're going to sample, you also need to know that you need consent from the person. So like I mentioned the Nicki Minaj and Tracy Chapman case, Nicki sampled Tracy Chapman's song without her consent. A remix basically involves taking an existing sound recording and adding, changing, and removing sound to make a new version of the work. So which is like the case of the Ameno Amapiano remix. You get? Whereas a mashup is combination of two or more samples of sound recording into a new work. Interpolation involves taking part of an existing musical work as opposed to a sound recording and incorporating it into a new work. Why sometimes it is confused with sampling. A sound recording interpolating a music work is different because it does not involve using any of the actual audio sounds contained in a pre-existing recording. Instead, new audio is recorded. But that's not the case here. That is not the case here. I hope with this definition, we've understood what I've mentioned and talked about in relation to this case, so people understand it better. Fair use defense will not save you if you sample someone else's song without clearing all the rights. So when clearing the rights, you need to determine who is the owner, who is the author. There's a difference. If in case you decide to just sample a copyrighted song, make sure you clear all the rights, get the permission in writing, not oral. Them say make a user, nothing make and a wee lie. If you sought permission like Nicki Minaj did and they refuse, it does not still give you the right to go ahead and reproduce the song, distribute it, and communicate it to the public, because those are exclusive rights for IP owners. So they have the right to sell, to assign, to license, to perform in public, to communicate it to the public, to distribute it to the public, to reproduce the song. They have economic right to earn money from it. They have moral rights as to how the work will be used at the end of the day. So basically, the act of using an uncleared song is an infringement. So you've committed an infringement, and you can be sued for several millions of dollars. And this is where cross-border dispute comes into place, especially now in this digital era where it's easy for a song. Let me not say it's easy, where you can't really predict which song is going to go viral and which song is not going to go viral, especially when you're using short video formats, to cram all of your creativity under 60 seconds. I made reference to that Nicki Minaj because you guys should really check it out. I did that with Mark Jaffe. Let me refer you guys to the episode again for those that didn't get it the first time. That particular episode was episode, give me a minute. So the thin line between fair dealing, sampling, and copyright infringement is episode 16, or my podcast, or 16 or 14, one of them. But it's best for you guys to do your research. Make sure that you're not found wanting. In the US, they have what is called the fair dealing principle, where we apply the fair use principle in Nigeria. Understand the difference between interpolating, sampling, covers, interpolation, sampling, covers, mashups, licensing. You need to know those words or terminologies that are common within the industry. Understand also the business aspect of copyrighted work. If you're in the entertainment industry, copyright it's like your go-to law at the end of the day. Fair use will not save you. 2019 we had the case of Tiwa Savage song, which was taken down by YouTube over the song One by Danny Young, who claimed that she had copyrighted his single Oju Tiwon. But at the end of the day, it was brought back online. Again and again, ignorance is not an excuse. Infringement of any form of intellectual property is a grave sin. I hope going forward we begin to take intellectual property seriously. We begin to respect intellectual property in Nigeria. From all of the cases, 20 cases, my highlights for this year that I've cited, I hope we learn something new. I hope we do things differently. I hope people begin to take copyrights more seriously abroad. I hope, not abroad, in Nigeria basically. Everyone needs to be in the know of how intellectual property interfaces with their sectors. So yeah, as a side, I have a not news, but basically my IP news for today is that we have the World IP Day has been fixed again. It's consistent, but then this year, the theme for this year is IP and youth innovating for a better future. So tag me on your World IP Day event. I will be organizing one with the Intellectual Property Society of Nigeria in collaboration with Tech Hive Advisory. And so we've come to the end of our 2021 IP series highlights for the year. I hope you guys had fun listening to these. If you would like to join me in next year's IP highlights review, do send me an email to ipseriesinfo@gmail.com. And yeah, compliments of the season, and see you guys in my next episode. Mwah.